I wrote the description of this panel, and I did mean it. It's a highlight of the conference. It is a candid Q&A with the Department of Justice's Principal Deputy for Tax, Ciraolo, and she is being interviewed by my co-chair, Scott Michael, who you know is going to ask her probing questions and make her uncomfortable.
Not prepared.
And as I said, and I stand by it, you will not want to miss this chance to hear Caroline's insights and perspective. So take it away, you guys.
Thank you very much.
All right.
We are delighted that Caroline is here. She took a red eye last night from California. She is indefatigable. We
So if I fall off, it'll
Right.
be like a Rosanna Dan.
we really appreciate you being here. So I think I'll just start off and ask you what's going on at the tax division, and we'll take it from there.
So, as most of you know, I've been in the tax division since January of 2018. I have more titles than you can shake a stick at, but essentially I've been serving as the head of the tax division, and things are great at the tax division. We are extremely busy, and I am truly honored to work side by side with the men and the women in the tax division, both in the civil and criminal trial sections and in our appellate sections. We currently employ about 370 attorneys and about 130 administrative staff. For those of you who are keeping track or familiar, about 2 years ago, we were at 300 attorneys, and that was following sequestration, hiring freezes, budget cuts. So we have staffed up. We are fully staffed at the moment, and this really allows us to focus on our priorities. Our priorities, we have several priorities right now. As you know, we're a litigating component, so we are charged with pursuing and enforcing the tax laws through both civil and criminal litigation. Among our top priorities are traditional legal source tax offenses. These would include our increased focus on employment tax offenses and the civil employment tax work that we're doing. Offshore related matters, the concealed accounts and assets overseas, fraudulent preparers and promoters of abusive schemes, and a variety of other areas. So today I'm delighted to be here to talk about our offshore priorities, and during the Q&A you can ask me anything you like. I can't promise to answer it, but I'll do my best.
So you mentioned traditional tax enforcement cases. There's been a lot of press about the IRS's activities in things like identity theft, which of course are hugely important to the integrity of the tax system to go after that sort of thing. And the criminal investigation division, like the rest of the IRS, is sort of resource challenged right now. Are you still seeing referrals in sort of what we would call traditional tax cases?
Yes. Yes. Since early 2015, we've increased our focus on employment tax offenses. That's both civil and criminal, but employment tax, as you know, falls into the traditional legal source tax offenses, and we have made those a top priority within our civil and criminal sections. But we're also seeing your traditional legal source cases, your 7201 tax evasion, false returns, client conspiracies, and obstruction, impeding and obstructing the IRS and the due administration of the tax law. So we are seeing these cases. They remain a top priority of ours, and you'll see them going forward.
So since we're an international conference, let's sort of focus on that. The Department of Justice instituted a program for Swiss banks back in the tenure of Ms. Keneally, who will be on not the next panel, but the panel beyond that this afternoon. And a number of banks, some 80-odd banks, Category 2 banks, came in and obtained non-prosecution agreements, provided a lot of information. One of the things that these banks provided was something called a lever list, where the bank had to identify account holders who had been at that Swiss bank, but during the period of August 2008 forward, closed their account at the Swiss bank and moved the money somewhere else. And so this is called a lever list. It is a list of these accounts that moved either to other banks in Switzerland or other places around the world. What is the department doing in terms of following up on this data? Are you looking at this data? Are you pursuing countries other than Switzerland, other individuals, and so forth?
So let me start by saying the leaver list is an extremely important part of the Swiss Bank program. I'm often asked whether the Swiss Bank program is done. Are you done? We are not done. We are in the legacy phase of the Swiss Bank program, largely reviewing the tremendous amount of information that we have received and continue to receive from the banks that participated, including the leaver list. We are using this information to follow the money and using data from other sources outside of the Swiss Bank program to follow up on these matters, to identify potential targets, both individuals and entities, and to pursue those cases. This information is helping us in pending investigations that have been pending for some time and identifying new targets and new areas.
And this is outside Switzerland?
Correct.
So this is countries, other countries where people may have moved money, Singapore, Hong Kong. I know you can't identify countries, but certainly in our practice we've seen cases where people move money to Israel, Singapore, Hong Kong, or even a country where their sister lived, Germany or France or something like that. So just to be clear, the leaver list data is being used sort of for a global look at where the money went.
Right. A lot of the U.S. account holders that left Swiss Bank went to other Swiss banks and then went outside of Switzerland. And we're following the money to jurisdictions across the globe. It's important to know that the tax division prosecutors are working side by side with agents from IRS criminal investigation to review this information, scrub the data that we have, and build new cases. So we're not just working on our own in this regard. The other result of this is that our phones are ringing. Individuals and entities are contacting us, and not just banks. Insurance companies, asset management companies, corporate service providers. They're calling us to either report that they've engaged in illegal or criminal conduct and wanting to talk to us and cooperate, or to come forward with respect to individuals that they are either associated with or aware of that have engaged and want to provide that information. So this is producing a lot of information, a lot of potential cases, and we are well outside of Switzerland.
How about whistleblowers? Are you receiving information from whistleblowers?
Yeah, so anyone who's dealt with the department or the tax division knows that we've heard from whistleblowers for many, many years. Whistleblowers will call our prosecutors, and we've received that information for some time. Recently, I learned that the IRS whistleblower office is receiving 1,000 claims a month under the whistleblower statute, section 7623. And as you know,
1,000 a month?
1,000 a month was reported. And that includes both A claims and B claims. And for those of you that are not as familiar with the statute, the A claims are the smaller claims that come in where there's no mandatory payout based on the information provided. The B claims are claims where the amount in issue is $2 million or more. And if it's an individual at issue that individual had gross income of $200,000 or more in 1 year, we call those the larger claims or the B claims. We obviously have pending investigations. We're pursuing new investigations. And if there's information that's coming in to the IRS through a whistleblower claim that relates to one of our investigations or an area that we should be aware of, we want to know it, and we want to know it as quickly as possible. The IRS whistleblower office is working extremely hard. They have staffed up recently, but at the rate the claims are coming in, there's only so much one office can do. So we engaged in some outreach recently, and I reached out to counsel for whistleblowers, and I've said this publicly at other conferences, that if you are representing a whistleblower and you filed a 211 with the IRS whistleblower office, the Form 211 is your whistleblower claim form, and you have credible, concrete, substantiated information regarding material criminal tax violations, I'm interested in a copy of your 211. I would encourage you to write us a letter, detail the fact pattern, and explain the basis of the claim, include a copy of the 211. If you've supplemented your 211, include your supplement, and send it to the Deputy Assistant Attorney General for Criminal Matters, which currently is me. And then we will determine where it should go within the tax division. We are not standing up a whistleblower office. Let me be very clear. And we're not paying out separate awards. That falls within the statutory authority of the IRS whistleblower office. But if you have a client who's interested in bringing misconduct to the government's attention, and you have a client, or you are interested in holding folks accountable that are engaged in illegal conduct, then we're interested in hearing about it with respect to these claims. And again, we're interested in the 7623B claims, the larger claims. We're interested in criminal tax violations, and we're interested in cases where there is a credible, material, substantiated course of misconduct that we can pursue. And we want to hear from counsel. I'm not inviting whistleblowers to all of a sudden call my direct dial.
So, and I take it that whistleblowers are not necessarily restricted to people living inside the boundary of the United States of America. There may be whistleblowers coming from other countries, bankers, facilitators who decide to adopt a perhaps nice little retirement package by hoping for a large reward from the IRS.
Well, I can't comment on the awards they've received or what they may be entitled to, but I can say that we've received information from whistleblowers, both domestic and foreign, and both individuals and entities, and we expect that to continue, just as it has for decades in the past. But we're encouraging that outreach right now.
Just to follow up on your pitch for people to contact you, the way the whistleblower statute works is a whistleblower gets paid when the IRS gets paid, when the IRS collects the relevant tax and other proceeds, and of course there's an issue on what that means that is now in flux. But I guess if you convict somebody of a crime, they don't have a lot of arguments on the civil side then, oftentimes to forestall collection of the relevant taxes. You don't need to comment on that, but it seems like it's a good idea to get the tax division involved is the point that I'm making.
I would note that when we're pursuing our criminal investigations and prosecutions, we have restitution in mind. And as you know, under the Firearms Excise Act of 2010, when restitution is ordered in a criminal tax case, it results in a restitution-based assessment, and that assessment is not subject to challenge. So we are pursuing restitution orders in our criminal cases, and oftentimes defendants will attempt to pay those in advance of any sentencing for obvious reasons.
One of the things in the last panel, or the second to last panel on EOI that I was interested in was the reference to spontaneous disclosures. I don't know whether you can answer this or not, but are there situations where spontaneous disclosures from other countries' tax authorities may have resulted in investigations or prosecutions in the U.S.?
So I can't comment on any particular spontaneous disclosures. Tina spoke about these. They obviously are a source of information for both the United States and our treaty partners. I don't know if everyone's familiar with spontaneous disclosures, and Tina mentioned this quickly, but it occurs when a tax administration comes across information that officials believe would be of interest to tax administration and compliance in another country, one of their treaty partners. When that occurs, the official, the competent authority of the foreign government can just disclose the information to the competent authority of its treaty partner, and that's called a spontaneous exchange of information. So certainly those do occur, and I think the takeaway from this, if I can pivot for just a moment, is that there are so many avenues for the government to obtain information in both civil and criminal tax investigations. Being here at this conference is a really good move for anyone who is practicing in this area, because you're learning so much today about those methods and those avenues. And these are tools that we will use whenever appropriate in our cases. So we're always looking for a cooperative way to obtain information. We may start with, serving a Title 31 subpoena, or trying to get a waiver from the individual themselves and obtaining the information. And from there, we're going to use our treaties and our agreements and other methods that we can use, either bilateral agreements or multilateral agreements. You're all familiar with FATCA and the IGAs. There is a tremendous number of ways for us to get information. And in this day and age, look around the country, look at what's happening, right? We are in an age of financial transparency, and everyone, all countries, are interested in combating global tax evasion. So there is a real interest here in helping your neighbor. We want to help them, they want to help us. We're all trying to get to the same place, which is voluntary compliance of our own citizens, collecting the revenue that we need to run our country, pave our roads, fund our schools. So I think now more than ever, it's very difficult for people to hide in the shadows across the world because most countries are engaged in this type of cooperation.
So, sticking with the treaty issue, one of the things that's been interesting over the past few years with regard to Switzerland is the Swiss have, of course, a process where if the Justice Department were to serve a treaty request on Switzerland for information about a particular American account holder, notice would be given. So if I have a client and the client is the subject of an investigation, the treaty request comes in, my client or his lawyer in Switzerland gets a letter saying, gee, the Department of Justice wants in, or the IRS wants information about your client. That's a good thing to know. But I take it that's not true in a lot of other countries, and that there are treaty processes with other countries where your client may not necessarily get notice that the department or the IRS is seeking information.
Right. We have a vast number of tax treaties, agreements, and other agreements with countries across the world, and each one has its own kind of nooks and crannies and provisions. So certainly that would apply in some countries. I can't speak to specific requests filed with specific countries or specific cases. What I can say is we are well beyond Switzerland at this point. We are pursuing investigations that touch on jurisdictions around the world, and certainly we're pursuing and using all tools available to us, including tax treaties, including TIAs, and including obviously the IGAs. So I think that you will see, if you're involved in these cases and you have a client that is the target of one of these investigations, you should not be surprised to see that we're using these tools to gather information.
So again, you may not be able to answer this in any degree of specificity, but so these treaties are obviously mutual. The other country, we can ask them, they can ask us. Are we getting requests from other? You're reading the paper that some government has raided the corporate office of some American company, or some individual who has a U.S. connection is under criminal tax investigation by the Spanish or the French or the Germans or whoever. Are we getting requests, to your knowledge, from other countries to help? Are we cooperating with other countries with their own criminal or civil investigation?
So I think your first point was the key point here, that these are bilateral agreements or multilateral agreements. So we're entering into agreements with another country. That doesn't just flow one way. The information flows both ways. The GAO issued a report in September of 2011 where they reported that I think it was 5,000, about 5,100 requests were flowing during a certain period, and 4,000 plus of those were incoming. So the majority of the requests, at least in that time period, were incoming. And we have made public announcements about some of those requests. We had the Deling case with the collection assistance, and there was the request from the Netherlands. So, and these are public releases that are out there. So yes, our treaty partners will seek assistance from the United States, just like we will seek assistance from our treaty partners, and I expect that to continue.
If I recall, there was a John Doe summons, I think, to Norway, am I right? A couple of years ago, so we may see more of those too.
Yes.
Yeah. One of the other mechanisms at the department's disposal is obviously the subpoena power. And you made a little news in the last year or so, I think, with the service of what's called a Bank of Nova Scotia subpoena on UBS in Miami, seeking records out of UBS in Singapore. So just for those of the Bank of Nova Scotia subpoena comes from a case back when, in the century ago when I started practicing law, where the Bank of Nova Scotia in Cayman, I think it was, the Justice Department wanted information from that bank. Of course, Cayman had bank secrecy. They served the subpoena on the Bank of Nova Scotia branch in Miami. They contested the subpoena, and in that context where you have a conflict between U.S. law and federal law, you go to a federal district judge. The judge weighs various factors as between foreign law and U.S. law and decides in favor of the Department of Justice. So in that case, the court decided in favor of the Department of Justice to enforce the subpoena that became known as Bank of Nova Scotia subpoenas. So there was one served on UBS in
Correct.
Miami for the Singapore records, and if I recall the news, UBS actually delivered those records. I can't remember the specific. Are we going to see more of those in the appropriate cases?
So when records are located outside the U.S., but they're in the dominion or control, in our view, of a domestic entity, this certainly is an option. We don't issue, obviously, the administrative summons. The IRS issues that during the examination, but they would come to us for enforcement of the Bank of Nova Scotia summons. The department may issue a Bank of Nova Scotia subpoena in a criminal case, and then we would, of course, the department would seek to enforce that subpoena. We don't take these cases lightly. It's one of the reasons probably why you haven't seen a tremendous amount of Bank of Nova Scotia enforcement proceedings over the last 10 years, but it is a tool, and it's a tool that we view as available where appropriate. It requires a balancing of our compelling interest in investigations and examinations with respect to taxpayers and our nation's tax laws, and a balancing of the foreign country's interests and our foreign relations. We did pursue Bank of Nova Scotia summons enforcement in the Saul case down in Miami, where we served UBS branch in Miami. And then when the documents were not produced on the grounds that it would be a violation of foreign law, which was Singapore, we pursued enforcement proceedings. And after we filed the petition, UBS produced the documents. So I think that's very telling. And I think I know that our interest in enforcing our tax laws and holding taxpayers accountable for criminal conduct will outweigh in many cases the interest in concealing the identity or keeping bank records secret in a foreign jurisdiction. And again, it's a case-by-case basis. We don't take these lightly. We talk to a lot of stakeholders in these cases, but in that case, it was completely appropriate to pursue it. And in future cases, it will be appropriate again.
Yeah, it's hard to imagine a federal judge, given the calculus you just laid out, saying, yeah, we're going to agree to support Singapore bank secrecy here instead of the interest of the Department of Justice. I mean, I think another reason why you may not see too many of these has to do with the required records issue and the fact that the law now seems to be fairly well settled that there's no Fifth Amendment Act of Production privilege with regard to a summons or subpoena for records of foreign accounts, at least over a 5-year period. I think what the tax division began under Caplin, I think you are 8-0 now in the circuits on this. Have you declared victory on this issue and assume that that will now be the law of the land?
Yes, I'm very proud of our attorneys in this case.
So, the circuits have been wrong before, though.
Right, that's true. The other thing, to shift gears a little bit.
Could I say one thing about that?
Yeah.
I don't want people to think that because we've served a Title 31 subpoena seeking records related to foreign accounts, that they would not then be the subject of a request pursuant to a treaty or an agreement. They are not mutually exclusive. And so while we may serve a Title 31 subpoena and obtain records directly from the taxpayers with respect to what is required by the required records doctrine, and when you look at that, it's not every document under the sun, they are often followed by additional requests and pursuits for additional information.
Okay, so shifting gears just a little bit to the sort of the civil side. There clearly has been, over the last 3 or 4 years, an enhanced focus on the part of the IRS with regard to the penalty that they can assert and collect upon litigation for the willful failure to file the FBAR form. It's a penalty, for those of you who don't know, it's a penalty of 50% per year for a willful violation with a 6-year statute of limitations. The IRS now has internal guidance out that it would generally limit that to 1 year, maybe 2, but that's, of course, sort of non-binding guidance. There have been a few cases brought, Caroline, so far over the past 4 or 5 years, but I think practitioners, just seeing the landscape of audits and appeals, are expecting many more. How is the department going to manage this caseload? Is there a centralized review process? How is the tax division going to sort of take this next step as more of these cases come in?
So anyone who's familiar with the way the IRS and the department work with respect to civil referrals is we receive referrals from the IRS for civil litigation matters, and they run the gamut of issues, including suits to collect with respect to FBAR penalties, and not just willful, but non-willful penalties. Right now, there are about 36 FBAR cases pending across the country. That includes both affirmative litigation, which would be our suits to collect within 2 years of the date of the assessment, or defensive litigation, where someone is, the taxpayer is filing a suit because they paid and they're filing a refund claim to challenge, or they're challenging, the underlying regulations of the statute. These cases involve a variety of issues. Some of the issues that we've seen come up are service of process, burden of proof, venue and jurisdiction, computation of the penalty, spousal liabilities, and obviously Administrative Procedures Act challenges, among other things. I do think this is an area of growth for us. We treat these cases like we treat every case that comes over from the IRS. We look at facts, we review the file, and we apply the law as we understand it, both the statute and the regulations and any other applicable guidance. So you will see consistency from the department in these cases because that's the pattern we follow with all of our work from the IRS. We make an independent decision with respect to our litigation decisions. If you've ever looked at the statistics here, you know that in 2007, there were about 330,000 FBARs filed because of all the enforcement action that's happened over the last 8 years. We are now over 1 million FBARs being filed. I don't think that's because all of a sudden another 700,000 people opened accounts. I think that is a result of the offshore compliance efforts by both the IRS and the Department of Justice. So we're seeing more compliance, but if you look at that statistic and then you consider that we have about 8 million expats that live overseas that obviously have banking relationships, not to mention the taxpayers that continue to reside in the United States and seek to evade their tax by concealing accounts overseas, we still have a ways to go, and there's still a lot of movement or space in there for enforcement action. So I do think this is an area of growth. I think we'll see more out of it, and we're all going to work together to develop the law in this area.
So last question has to do with disclosures. Offshore voluntary disclosure program has been in place since March of 2009. A couple of years ago, the IRS adopts a streamlined program for non-willful persons who will certify their non-willfulness to come in and make it, sort of go through door number 2 instead of door number 1. The tax division has been on record for the last year or so, the public comments that there is scrutiny occurring in some cases, and just to put this in context, it goes, at least as far as I can tell, this would go back to the Swiss bank program, because the banks, in order to mitigate the penalties that they had to pay under the bank program, had to provide evidence to the Department of Justice that account holders had reported their accounts. And those reports could be timely, which most of them were not, or they could be through one of the formal offshore disclosure regimes that the IRS had announced, so long as the bank could demonstrate that it was the bank that sort of pushed this account holder into disclosure. So, just to put this in context, the banks come into the tax division and say, all right, we have 300 accounts. We don't think we should have to pay a penalty on 280 of these accounts. And here are the offshore disclosures for the half of those, and here are the streamlined disclosures for the other half, so we don't have to pay a penalty. Thank you very much. So as I understand it, what's now going on is the department is looking at some of those disclosures and trying to figure out whether the account holder selected door number 1 or door number 2 correctly. Is that still going on?
That's absolutely correct. So this is all part of our review of the information that we've received through the Swiss bank program and other mechanisms, including waivers from a lot of U.S. account holders. They sign waivers whether they were in compliance or not. So we have copies of certain many streamlined packages. Not every single one, because some of them were simply filed with the IRS, and we may not have that. But we certainly have a lot of streamlined packages that we are reviewing, and we're particularly looking for cases where a taxpayer willfully misled the IRS. They made false statements on their streamlined narrative in an effort to avoid the penalty, and in doing so, really engaged in impeding and obstructing the IRS and the due administration of the tax laws in an effort to avoid coming into compliance and paying their appropriate penalties. We're very interested in those cases, and I do expect that you will see some of those cases result in criminal investigations and prosecutions, and some perhaps in civil enforcement action. I do think that's an area ripe for review. A similar area might be the expatriation forms, your Forms 8854, where the bank would come forward to mitigate and say, this account holder expatriated, and here's the 8854, and they check the box. I've been in compliance for 5 years, and here's my U.S. tax liability. We're going to take a look at those, and we're going to see, are they really in compliance? Because if not, that's a false statement, and we're interested in pursuing that as well. It's our job to hold people accountable. IRS recently announced 48,000 taxpayers came into the streamlined program. That's a lot of taxpayers. 55,000 came into the OBDP. Okay, we're nearing $10 billion of collections through the OBDP. It's our job to make sure that the people that chose streamlined chose appropriately. It's not fair that everyone who came into the OBDP and paid the penalty and did the right thing and came into compliance to have a lot of people just lie their way through a streamlined narrative. And we intend to hold those folks accountable. So you will see more activity in this area. The other thing we're pulling out of the streamline and the OBDP are all the pieces of a taxpayer's evasion. So who was involved? Who said what? Where was it done? What jurisdiction? And that includes the facilitators, both domestic and foreign. Now, I do want to say, just because we have a name of a bank employee or an accountant or a lawyer doesn't mean that all of a sudden they have become a target of a grand jury investigation. I want to be very clear about that. However, if we do have a name and there are allegations of misconduct, there's allegations of criminal conduct, we're going to be looking at that. And we don't stop at a certain level. So we'll look at everyone from the face-to-face person with the client up to the C-suite, depending on the conduct involved. But just having the name doesn't automatically start a criminal investigation.
Any closing comments?
I'm really happy to see this room full. I think this is an important area. In the last 2 years at the division, and I am so fortunate to have this job. I embrace every day and try and work around the clock to justify my salary. But it's clear to me that almost every aspect of tax enforcement is has an international piece to it. Whether you're a civil trial lawyer, or you're a civil transactional lawyer, or a prosecutor, there are international aspects to the work that you're doing. And so I think it's really important that you're here. I think it's really important that you review the materials when you go back to your office and learn this area of the law. You will be better attorneys, better counselors for your client, and better able to advocate on their behalf. So thank you.
Thank you, Caroline. Thank you. Thanks to your colleagues.